Okay. So this course is a legal issues concerning education. For today and next week's discussion, we would not be discussing itong ating Education Act on the Philippines, no? Because I would believe and I have the assumption that our classmates here, our participants here, are more of admins, deans of education. We will just be tackling those legal issues that are not necessarily being looked onto with in admin in school administration, no? Yeah, it's okay to have close cam. Oh, it's okay. I'm not requiring everybody to have their cameras on. In fact, my camera is not on as well, diba? For better bandwidth. All right. Thank you very much. So hopefully you're hearing me very well and PowerPoint I presented clear, no? So yun, mm, excuse me na lang kung medyo magtatagalog ako from time to time for me to be able to explain further the legal issues with regards to this matter. Another is that our course would be tackling legal concerns in Philippine jurisdiction. Let me just discuss this caveat before our kumbaga, this discussion would only be for Philippine setup. If you are working abroad, for example in Dubai or in USA, like one of our participants here, uh, these laws might not be or are not in fact applicable in your jurisdiction where you are right now, no? So these laws that we are going to discuss in jurisprudence would be involving Philippine jurisdiction. So it would be applicable in our home country, Philippines. All right. So if we have sometimes we have foreigners that are joining our class, we have from China, we have from Taiwan. So these foreigners, or we also have sometimes from India. These foreigners they tend to ask whether or not it's applicable in their country, you know. But I would like to introduce that these laws that we are going to discuss, it's just applicable in the Philippine jurisdiction. All right. So my the presenter for today is let me introduce myself. I am Attorney Clanas Gabriel Rebadillo, also a CPA for profession and a lawyer. I've been teaching as well in St. Paul University and University of Santo Tomas for almost 8 years. So I know some of the participants here may have been participating or may have been in the education practice for more than decades already. Even had one participant who has been in the education practice for 30 years. What more could I share, di ba? But later on, she was clarified with regards to legal intrinsities or nitty-gritty of nitty-gritty of these laws. Wait lang, there's a concern with our chat, no? Just like to share my email address. I'm afraid you don't have. All right. Let me share my email address to you, so to everyone later on, so that you may send. Later on, I'll send uh, I'll send an instruction how our attendance would be. So for concerns later, I'll read the chat later na lang. So the chat has been being flooded right now. So yun. Your concerns with regards to attendance later na ha sa chat. All right. So going back, no. Uh, so yan. So hopefully dito kasi yung ano natin is more of the nitty-gritty Yung mga hindi napapansin ng mga admin natin or mga school administrations, hopefully we'll be able to have to give you some ideas with this. Apart from any introduction, no. I was also part of Estrada in Aquino Law. I guess everybody here are familiar with Attorney Estrada Aquino or Attorney Estrada, Joseph Estrada, who is I would say an expert in education. He was also the ghostwriter for the K to 12 law, no? I was part of his team. At that time, I was more of handling in the taxes of 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 schools. But currently, I'm no longer connected with his firm. I have my own firm, which also caters to schools, especially for their taxes. But in their concerns like yung mga ano nila sa DepEd, I would refer na lang sana kay Attorney Estrada. But more of the taxes, yun yung ano ko. Alright, so without further ado, let's go to our discussion for today para maaga tayo matapos. Alright, so the first question would have to be, in regards to education practice, is what is the supreme law of the land? The ultimate law of the land even provided protection to education here in the Philippines. And it is no other than the Philippine Constitution of 1987. Okay? The date is very important then. 1987 Philippine Constitution. The Constitution as the ultimate law of the land provides structures, general policies, foundation of the society, which includes education. Okay? So it also provides the rights and limitation. Remember this, if we have rights, if each individuals have rights, individuals may involve juridical or natural persons. If these entities or persons have rights, their rights also has limitation. And these limitations are set by the Constitution. And these rights are highlighted and protected by the Constitution. And one of the most important rights of each individuals here in the Philippines is their right of education, which hopefully we will be able to have knowledge, or we would be able to recall, to have more foundation with regards to our freedom of education, right of freedom of education, when we discuss today's constitutional basis of education practice. Okay, for today, we'll be discussing constitutional basis. For the next session, we will be discussing other laws, for example, tax, labor, and other kinds of special laws. For but for today's session, we will be focusing on Philippine Constitution because rights and limitation arises from this law. Okay, provides the state's policy. If you would know, no, if you would read the Philippine Constitution, and sometimes ito ang kinakagalit ng mga Pilipino. Bakit yung Philippine Constitution, or why is the Philippine Constitution written vaguely or very generic, or better say this, very general in nature? Vague ang pagkakasulat niya, hindi siya direct to the point. Okay? Our Philippine Constitution, or any constitution at that matter for every state, no, kahit yung American Constitution, they're written in such manner to be vague or in general form. Why? Because the Constitution aims to be flexible for whatever time it may be used. No? So, generational kasi yung Philippine Constitution, it should test the test of time. Kaya it should last the test of time. Kumbaga kahit anong technology yung mangyari dyan, dahil generally written ng Constitution natin, it would still be applicable. Okay? And sometimes ang reklamo, bakit sulat naman sa Constitution, hindi naman ina-apply? Because the Constitution only provides the principles. But if the Constitution provided already how it is going to be executed, the Constitution should be utmost applied. Okay? It should be the utmost law of all. So if there's conflict between a general law and and the Constitution, which would win? The Philippine Constitution would be governing. All right? And how is education being prioritized in the Constitution? Okay? A little trivia. In our 1987 Constitution, education has been mentioned for at least 22 provisions. Okay? It has been mentioned at least 30 times in our Constitution, compared to life, which has been only used for 6 times. Hence, we could also say that education is being prioritized by the state. All right? That's how important education is. In theory, in theory. All right? Let me give you some examples as stated in our Philippine Constitution, which should have been given the utmost importance of all. All right. Under Section 17 of Article 2. Per, all right. The state shall give priority to education, science, technology, arts, culture, and sports to foster patriotism and nationalism, accelerate social progress, and promote total human liberation and development. In fact, yung ating kasing Article 1 that provides the territory of the state. Okay? That's important kasi the first thing that the Constitution provided is the territory. What is the Philippine territory? Article 2, you would say it will have to given the second priority, okay, other than to protecting the land or the territory of the Philippines. The Constitution gives priority to education. That's why it's been mentioned in Article 2. All right. More so, education has been given a separate article in the Constitution, which is Article 14. Okay. Which also provides access in quality education. Let's give some examples. Section 1 provides the state shall protect and promote the right of all citizens to quality education at all levels and shall take appropriate steps to make such education accessible to all. This first section provided yung reason or the basis why academic freeze is not allowed by the DepEd or CHED during the time of pandemic. If let me give you some background or history. Some point of time during the pandemic, there are students who are crying aloud or or what they call it, protesting. But there should have been a academic freeze. I don't know if everybody had remembered at that time, no. Na yung mga students, they're even rallying na for the protection of everybody, kailangan daw magkaroon ng academic freeze during pandemic. What was this request by the students? Okay, di naman sila 100% kumbaga population of the student eh. This is just a sample sa population of students. Is this request granted by our state? No. In fact, if the academic freeze was granted by the state or the DepEd or the CHED, it would be a tantamount violation of the Constitution. Why? If just one person or just one student would like to have to continue his education during despite the fact of a pandemic, kahit isang estudyante lang yan out of everyone, the state shall protect and promote such students' right to a quality education. All right? Emphasis provided, underline. That's why kahit student lang umaray dyan na, hindi, wag nating academic freeze kahit online yan. Despite the fact of a pandemic, kailangan magkaroon pa rin ng school kasi ayoko nang mag-stop. Gagraduate na ako next year eh. Okay? Dahil lang sa isang request na yun, ayun no, lahat. In fact, kahit wala mag-request, even despite the fact na wala mag-request dyan, the state cannot freeze education even for just 1 year. Okay? Why? Because in the Constitution even provided, as expressly provided, that it shall protect and promote the right of each citizen to a quality education at all levels, at all levels. Unless otherwise there is may ibang circumstances that extraordinary circumstances that it should reach any school year. But in that case, pandemic, we could have our online session like what we're doing right now, diba? We could still continue our education through online or any other means. But why do we have to freeze it? If you do not want to study at for the school year, it's your right not to enroll. But you cannot infringe the right of the other just because you wanted to have something. Okay? So that's one limitation to a right. And that's also a limitation of one's right and a protection of the other's right. Okay? That's a clear example of that. Section 2 of the same article, Section 2, Paragraph 2 of the same article, provided that the state shall establish and maintain a system of free public education in elementary and high school levels. without limiting the natural right of parents to rear their children. I would like you to give emphasis on this, no? Elementary education is compulsory for all children of school age. What does this mean? Section 2, paragraph 2 of Article 14 of the 1987 Constitutions provided that the state shall provide free education for elementary and high school. Okay? Bakit yung PUP sometimes or yung UP nagbibigay din sila ng college education? But that's not for all, 'di ba? Unlike yung elementary and high school, public schools, these are open for all. Okay? It does not discriminate. Okay? I'm not saying that discriminating yung yung mga schools na nabanggit ko. These are college level. College levels should meet yung students in college level should meet their standards of grades, their attainment, their qualifications before they would be able to provide a free education. But in elementary and high school, it is compulsory, shall be free because the Constitution had provided it should be free. Okay? When we say free ba, kailangan ba pati yung school uniform free? Not necessarily. What the state or the Constitution had provided, that the education, yung tuition, ang free, sorry. Yung tuition ang free. Alright? Second sentence provided that elementary education is compulsory for all children of school age. Okay? So what is elementary education and why is it compulsory? So elementary education here in the Constitution, provided in the Constitution, is not necessarily yung ating grade 1 to grade 6. Okay? When we say elementary education in the Constitution, it provides basic education. Okay? Basic education. So, yung K to 12 ba, is it mandatory? Yes, it is mandatory. Later on, we will be discussing that the case itself, okay, as decided by the Supreme Court. Some groups has been contesting na hindi dapat mandatory yung K to 12 if the students or the parents does not want their children to enter to grade 11 and 12, they could move forward to college since it is not compulsory. Okay? It is compulsory. It's provided by the law and the Constitution. Later on, we will be discussing why. Okay? Bakit gano'n? Eh, ang sabi lang dito elementary, no? When the Constitution provides elementary, it means basic education. Okay? Complementary roles and reasonable regulation, okay, by the state. Under Section 4 of Article 14, the state recognized complementary roles of public and private institutions in the educational system and shall exercise reasonable supervision and regulation of all educational institutions. What does this article means, no? Means it provides that the state recognizes the vital role of private institutions. This might be non-profit or non-stock schools. It might be for-profit schools because the state cannot on its own provide free education. Or sometimes the state on its own cannot provide quality education. That's why private institutions are most likely being being used by its citizens because they would like to have their quality, mga ganyan. So the state recognizes it, okay? And because of its recognition of private institutions, the state will just exercise reasonable supervision. What do you mean by reasonable supervision? It will not control, okay? Unlike in public schools, the state controls. Kasi it's ours, eh, 'di ba? But for private institutions, as to the means and method, it shall not, okay, again, it shall not control the school's operation. O, dapat ganito gross profit mo, dapat ganito itsura ng school. No. Dapat ganito uniform. No. Alright? The state shall only exercise reasonable supervision. The means and method on how it should be done should not be controlled by the state, but it is under the sound discretion of the administration of the private institution. Again, let me highlight, it should be the private institution. This is where we go to academic freedom of the administration of the schools. The admin of the schools, so the school's owner of private institution, also has the freedom of education in exercising their sound discretion on how, on the means and method they would have their education program be provided. Kung gusto nila online, so what? But of course, there's going to be guidelines for it. The state will provide guidelines. As state policy, ayaw namin ng 100% online. You may want it to be 50-50, ganyan, ganyan. These are just merely guidelines. The school still has the academic freedom for it. Okay? Because the state only exercises reasonable supervision. Sometimes in practice, no, I would be honest with this, no, especially with the DepEd. Sometimes they tend to cross the red line. It's a very thin line between a reasonable supervision and control. And from time to time, they cross that line. So that's why, yeah, nagkaka-clients kami na ganyan. To, to give emphasis that the state should not be crossing those lines. They do not own school. All right. What they could just do is have supervision to provide guidelines or policies. Ex- Not as to the means and method. This is the end. Kumbaga, I wanted the state will provide the end result. This is what I wanted to have for my citizenship. Okay, citizenry. I want them to be professionals. I want them to know on how to do it. It is on the private institution. Now, if the state would like to have its own means and method, do it in their public schools. All right. This is the basis of the right of the public. Oh, sorry. This is the basis of the right of the private institution. Section 4 of Article 14. All right. Hopefully, everybody's able to catch. No, if I'm going too fast, let me know. Also, academic freedom of institutions and students. To give you some background, to academic freedom is three-way party. Okay, when we take three-way party, tatlo yan. Okay, it is a academic freedom of the administration of the school, academic freedom of the instructor or the teacher. There's also an academic freedom of the students. Okay, let's go to the academic freedom one by one. All right, that academic freedom shall be enjoyed in all institutions of higher learning. If you would see, it is of higher learning. What do you mean by this? It refers to college and higher levels of education. Okay? Every citizen has a right to select a profession or course of study subject to fair, reasonable, and equitable administration and academic requirements. So in this yung paragraph 3, no, any person has the right to select whatever profession or course they would like to take. But this right also has limitation. Such limitation is if you pass the NMAT or you pass the board exam, you may just after passing, then you may exercise the profession. But not because you wanted to become a lawyer, not because you just wanted to become a teacher. You just wear the uniform, you become a teacher already. That's not how the way goes, no? There should be a fair and reasonable and equitable administration. Oh, sorry, admission of academic requirements. All right. Later on, we would have a case regarding that the the freedom of education of students versus the freedom of education of the teachers or the school admins. It is always a clash. Cases with schools that we handle usually are clash between the principles of the freedom of education of the students and the freedom of education of the institution and the teachers. All right. Later on, we would be having a class. This is just merely an overview or the basis. Say we would like to when we explain to client, we always say na when we refer to a right that you or the remedy that you would be having, we would like to share always or to footnote. the basis of our statement. So before going to the details kung baga paano ine-exercise yan or in practice, I would like to show first to the class kung ano yung basis ng sasabihin natin mamaya. Bakit ganun ang decision? Bakit ganun yung ano? So these are the basis. Alright? Next, reasonable supervision and control, which we have discussed previously. No? So let's go to cases. Alright? When the 1987 Constitution speaks of the state's supervision and regulation, it does not in any means and it does not in any mean and control by only a reference to power of the state to provide regulation to ensure that these are duly implemented. Baga, more of the guidelines lang. It does not include the right to manage, dictate, overrule, prohibit, or dominate the school. The regulations, must not create in its center of higher learning an atmosphere of fear and restriction. Remember, class, that the 1987 Constitution was created at a time after martial law. To give you background, no? When we study law kasi we look to the history. Why is it created? What is the spirit of the law? Why is it like that? So that we would be able to understand and apply the law as it was supposed to be intended. So in the 1987 Constitution, this was created and issued at the time and effected at the time after martial law. And during martial law, the state has been controlling, okay? It's been in control of education as stated in our, no. I don't know if it's been revised now, no? If the history is being revised now, but it's what I know of my history, no. So that the 1987 Constitution, it was created, and the intention of the 1987 Constitution is to provide academic freedom for the three parties, the institution, the educators, and the students. Because with what they have experienced during the martial law, there's no freedom at all. It is being dictated, it was being prohibited, and it's being dominated by the state. All right. Hence, at the time of creation of 1987 Constitution, it did not provide and it even provided a protection that the state should only recognize reasonable supervision and not control over the private institution. Okay? Now, academic freedom. First, we try to learn the institutionals and academic freedom. Okay? Academic freedom includes the right of the school or college to decide and adopt its aims and objectives, and to determine how these objectives can be best attained, free from outside coercion or interference, save possibly when the overriding public welfare calls for some restraint. Freedom subsumed in the terms of academic freedom includes who may teach, what may be taught, and how it shall be taught, and who shall be admitted to study. This is the institutional academic freedom. The first party. Okay? The first party's education, academic freedom of institution. Okay, when we say institutional academic freedom or academic freedom of the institution, it is the freedom to determine who will teach. Kaya sila yung nag-hire. Sila yung nag-hiring process niyan. Who may teach, what will be taught. Kung gusto ng UP magturo ng course for Taylor Swift or whoever artist, it's their right because it is an institutional academic freedom. And how it shall be taught, kung gusto nila bagabi, gusto nila umaga, online, or face-to-face, inside the classroom or outside the classroom, it's their discretion. And who shall be admitted? Okay, it is considered as an institutional academic freedom or academic freedom of the institution. Let me give you a clear example of this. This is the case of Ateneo de Manila versus Honorable Judge Ignacio Capulong. Let me just have a water break. To give you, let me summarize na lang itong ano na to, case na to. Pero I'll still flash this. This case is actually doon sa ano with regards to, related to the hazing incident in Ateneo Law School. Si Lenny Villa who died during the hazing initiation of the Aquila Legis fraternity. Okay. When the authorities of the Ateneo de Manila University discovered that one of their first year students had died during the fraternal initiation rites, the university they found those parties involved, yung mga yung mga pumalo at hindi, no, everyone to be guilty of violating Ateneo's code of discipline. Okay, so they were reprimanded and they were even dismissed from the Ateneo Law School. Itong mga members na ano. The dismiss of the students were appealed and so let me give you a background. Yung mga members ng Aquila, itong fraternity, I would rather not say it, no? Baka may member dito. Yung mga members ito malalakas. Okay? Kahit nakapatay sila, malalakas pa rin sila. They have corrections. So they even appealed the decision of the Ateneo de Manila University before the Regional Trial Court of Makati, wherein Judge Capulong granted a temporary restraining order and ordering Ateneo to reverse its decision and reinstate the students. Imagine that. Okay? Imagine that. So Ateneo University Manila, a Catholic school, a Catholic private school, one of its students died during a fraternal initiation, which the school did not sanction at all. Okay. However, it carries the name of the school. Now, now the school, as a form of punishment, dismissed the students. Okay. Well, however, the students, despite the fact that they have been dismissed and because of their connection, they were able to file an appeal of the decision before the regional trial court, and the regional trial court provided that they should not be dismissed. Sinabihan pa yung school, masyado kayong mahigpit. Mali yung ginawa nyo. Ibalik nyo yung mga estudyante. Of course, aggrieved. Kamot ulo yung yung Ateneo dito eh. Aggrieved, Ateneo appealed even up to the Supreme Court the decision of the judge in Makati. The issue of whether or not the school is within its right in expelling the students from the academic community pursuant to its disciplinary rules and moral standards. Each school has their own code of conduct, diba? Siguro sa Ateneo at that time, very strict sila na kahit in fact I would be confident to say that any Catholic school or any school in particular is strict with regards to discipline and moral standards, especially if a student died brought by activities done by their students as well. Diba? What did the Supreme Court decided? Okay? The Supreme Court has said that they would be deciding in favor of Ateneo de Manila, that indeed Ateneo, as a corporate entity and educational institution of higher learning, are inherently endowed with the right to establish their own policies, academic and otherwise, unhampered by external control or pressure. Okay? This is a clear example that the state shall not take control of the academic freedom of educational institution. That the educational institution has the right to manage their own schools. They have the right to provide their own rules and regulation. Kasi sinasabi nung judge dito, hindi nyo pa naman napapatunayan na sila ang nakapatay eh. Is that even required? Diba? The mere fact of involvement and there's a difference between criminal law and school sanctions, ha? in criminal law, there should be a proof beyond reasonable doubt. Ibig sabihin, walang duda na ikaw ang pumatay. In school sanctions, in implementing and having the school sanctions in effect, such requirement in proof, okay, quantum of proof beyond reasonable doubt is not required. The mere fact of substantial substantial evidence or even preponderance of evidence. When we say preponderance of evidence in law, the mere fact na may connection ka dyan eh. You are already subject to the rules and regulation of the school. We may impose penalty against you. Alright? Hindi kailangan mapatunayan beyond reasonable doubt na ilan ang pinalo mo. Kasi let me give you some example ha. Sa court, pag sinabi, oh, isang palo lang, di naman nakakamatay yung isang palo, lalo na sa puwet ha. Paano mo nasabing pinatay niya? He might not be charged of murder, but but the school on its school's regulation may impose that any violence inflicted to any students is tantamount to dismissal. Hindi kailangan mapatunayan na ikaw ang pumatay. Any inflicting of violence, in fact, hazing, is prohibited in this school. Alright? So that is a decision of the Supreme Court. Upheld the right of Ateneo to dismiss these students who have been involved in such hazing activity because of their exercise, because Ateneo is just merely exercising their right of academic freedom of educational institution. Again, consistently upheld the salutary proposition that admission to an institution of higher learning is discretionary upon the school, same being a privilege on the part of the students rather than a right. If you would notice, no, ano ang mas mataas ang right? With regards to higher education, pag basic education, ayan, it's always in favor of the student. Because it is compulsory of the student, you cannot be discriminatory on the part of the student. But if it is a higher learning, okay, because compulsoriness is only for elementary education eh. For higher learning, which is for college or higher levels, discretion is on the part of the school. It is the school or the institution who exercises discretion, not the student. So the right of the student to have education in such school is limited only and is considered merely as a privilege and not a right. If it is a privilege, you shall be subject to the rules and regulation of the school. Si school ang bahala. Si school ang masusunod. Alright? Is there any questions with that case? Oh, if there is, we should move on, no? Ito, still, this is a new case. This is a new case. Hindi naman new case, but a different case. Garcia versus Faculty Admission Committee of Ateneo also. I don't know what's the matter with Ateneo. Gustong-gusto silang kinakasuhan ng mga estudyante nila, no? Pero just so happens na gano'n ang nangyayari. This is let me give you a summary of this, no? Pero para maganda kwentuhan natin. Maganda yung ano ko eh. Pero if you would like to read this, PowerPoint will be provided as well. Although the PowerPoint is also a summary of the case. Okay. So let me give you a background. There's a certain student, Picaris Garcia, okay, who enrolled dun sa parang master class in theology in Ateneo Theology Graduate School. At that time kasi, yung summer class na yun, parang ano siya eh, what do you call this? Parang, parang free taste of the school. Parang ba yun? How do I say this? Parang trial, sorry. Trial course siya. So if you enjoyed such subject, this course, we are inviting you to enroll in a regular schooling na. So during summer, si Ateneo Graduate School of Theology, they provide a trial school or trial courses. for those students that who would like to yung trial class. Yeah, very yes. Na ano eh, na it's in the tip of my mouth eh. Of my sorry, in the tip of my tongue eh. So hindi ko nasabi. Yun, trial class siya every summer. So one of the participants of the trial class is si Miss Garcia. Garcia is actually a nun, no? From I don't know which congregation. Pero ano, so she was able to enroll in such a trial class and she wanted to enroll in the regular class na in the first semester. However, Ateneo refused her admission and enrollment on the ground that during the trial class, she is frequently questioning and it's been found to be difficult in class. Grabe yung description sa kanya eh. Yung pilot testing, yung some call it pilot testing din. So during the time of pilot testing or trial class, the professors in the Ateneo Theology class no found Miss Garcia to be difficult to handle. Medyo morbid yung pagkaka-describe sa kanya doon. So hindi nila inadmit si Miss Garcia to dun sa regular class. Okay, dun sa first semester regular class na. So the head of Ateneo admission, si Father Sevilla, recommended that she seek same course in UST Graduate School sa Canon Law. Okay? Yun ang tawag sa UST, Canon Law. College of Canon Law. Yun ang ano, gumawa pa si Father Sevilla ng recommendation letter that Mrs. Garcia is a diligent student, ganyan, with honors, mga ganyan-ganyan pa. Okay? We would like to recommend her admission in that school, UST. So, sabi ni Miss Garcia, ayoko. Gusto ko Ateneo ako. I bleed blue. Yun ang sabi niya, I bleed blue. And also, other than that, she learned that after going to UST, if she enrolls in UST, it would take her 4 years to finish the same course. Unlike in Ateneo, it would only take her 2 years to complete the same course or sorry, the same program. Okay, not course but the same program. So compare naman, there's 2 years of difference. She would be able to finish the program in 2 years sa Ateneo. Whereas sa UST, it would take her 4 years. Because of that, she felt aggrieved. Ba't ayaw ko papasukin ng Ateneo? I have the academic freedom. See, there's a conflict of rights here, di ba? The academic freedom of the institution and the academic freedom of the student. So Garcia filed an action of writ of mandamus. What is a writ of mandamus? A writ of mandamus is a case that the party may file in order to compel another party to do a thing that is mandatory for them to do. So it is only applicable if it is a mandatory. Yung tipong hindi mo naiisipin. For example, nagkumuha ka ng NBI clearance, bayad ka na kapag tawag dito, biometrics ka na. Nung nandun ka na sa doon ka na sa releasing ayaw ibigay. Kailangan daw may padulas. Mag-writ of mandamus ka. Yun kasi there's nothing to think about. There's nothing to think about it eh. You just have to print it eh. Why don't you do it? Diba? So si Ms. Garcia filed an action of writ of mandamus compelling Ateneo to have her admitted in the first semester of the school year. Okay? So the issue as decided by the court whether or not Ateneo Graduate School had the authority and discretion in allowing Garcia to continue studying or not. In other words, tinatanong dito, ang question dito is whether or not tama ba yung ginawa ng Ateneo na hindi siya pagbigyan or dapat ba pagbigyan si Miss Garcia because trial class na ako eh. Kaya nga kayo ang contention kasi ni Miss Garcia dito is kaya nga ako nag-trial class eh. Kaya ang purpose nga ng trial class is 'di ba? Pag nagustuhan namin, automatically invited kami. And it is the discretion of the student whether or not I would take it would enroll or not. In this case ka, ako na nga nag-enroll eh. Ako na nga nagpupumilit na mag-enroll eh. Bakit niyo ako pinipilit na palabasin? Bakit niyo ako ayaw tanggapin? What did the Supreme Court decide? Well, the Supreme Court decided that Ateneo Graduate School of Theology has the discretion, and we shall deny the writ of mandamus. Hindi namin pagbibigyan na makapasok ka dyan. There is no right. Kumbaga, Miss Garcia, kung sinasabihan ng court, Miss Garcia, you do not have the right to compel Ateneo to accept you in this school year. Okay? There's no duty to admit, Miss Garcia. This is different from from the Education Act, wherein a student who has been enrolled for the grade 1 would continue, has the right to continue until graduation. That is for basic education. That is for elementary education. But this is a higher education. Kaya nga sa college pag ayaw ka ng pag-enrollin sa next sem, diba? They have the discretion for it. Provided that there is reasonable uh ground that you would be compelled not to enroll. In this case, Garcia was not even admitted. It was merely a trial course. Okay? Whether to test the waters, whether we would like you to be our student or you would like us to be your mentor. It is a testing of waters pa. It is a trial course. Ba? There is no duty on the part of Ateneo to admit you. There's no obligation. Okay? Father Lambino of Ateneo has the discretion whether or not to admit Garcia. Okay? What are the factors to be considered? As stated by the Supreme Court, to be reasonable. First is academic standards. Okay ba siya? Personality and traits. Character orientation and nature of Loyola School of Theology as seminary school. In fact, one of contention here of Ateneo is this program is offered only to priest male students, and you are a female. Why would you like to be enrolled in this program? Yun pa nga yung isang contention nila eh. And of course, ang pinaka-morbid doon, yung personality trait ni ano. So, ayan. So, it is an exercise of academic freedom. Wherein, as quoted, academic freedom is more often identified with the right of the faculty member to pursue his studies in his particular specialty and thereafter to make known to or publish the result of his endeavors without fear that retribution will be visited on him in the event that his conclusions are found distasteful or objectionable to the powers that be, whether in the political, economic, or academic establishment. So in summary, ano ibig sabihin nun? Para mas maintindihan natin. Sabi ng Supreme Court, when we say academic freedom, it is mostly identified to the right of the faculty and the institution. Okay? So mas attached siya dun sa faculty and the institution, wherein the faculty has the right to share the studies. Okay? Pursue his studies. Ibig sabihin niyan magturo. And to publish yung grades ng mga estudyante without fear of being compelled of distaste, objection, whether you like it or not. Gusto, diba? Tatay ko ang may-ari ng school, kailangan pasa mo ko. Ibang usapan yun, diba? Pero as much as possible, yung teacher or the institution has such right of academic freedom. Okay? It is the discretion of the professor, especially in higher education. Again, this academic freedom is mostly exercised in higher education. Okay? So what now? What do we think of now of the academic freedom of the students? Well, academic freedom of the students is limited to the what to take. He has the freedom to choose the profession, but subject still pa rin sa reasonable grounds of admission. So, limited yung rights ng student. Okay? Academic freedom is mostly attached sa institution and the educator, the faculty. So, speaking of, no, nandito na tayo sa individual academic freedom, which pertains to the academic freedom of the faculty. Okay? As a defined, it is a right claimed by accredited educator, as a teacher, and as investigator to interpret his findings and to communicate his conclusion without being subject to any interference, molestation, or penalty because these conclusions are unacceptable to some constituted authority within or beyond the institution. Let me go further. Let me just share an experience. This is a personal experience and experience of faculties that I have been able to become my clients. All right. Recently, yeah, nagiging trending na ngayon yan eh. Parang I'm not trying to to rant, no, but let me just give you some insight, no. Yung parang feeling entitled yung students that oh, dapat ano ako eh, hindi lang ako 98, dapat 99 ang grade ko. Ha? To the fact na to the extent na kailangan magreklamo sila to the dean, and then if that not favorable, nagreklamo din sa ano, sa CHED, sa Regent, lahat. So in all of their ano reklamo, of all of their complaint, what is the only answer? The only answer is that academic freedom is mostly attached to the institution and the faculty. Again, this is the ano, ito yung basis that the teacher itself, the educator must be able to communicate his conclusion, which is a discretionary act. Hindi siya ministerial act, ha. Yung pag-grade sa estudyante, this is discretionary act on the part of the teacher. It is the teacher or the educator who has the right to determine whether or not papasa yung student or hindi. Again, let me highlight, this is on a higher education, not necessarily to elementary. Pero yun, na hindi dapat siya masasubject to interference or molestation or penalty just because binagsak kita. In fact, yung experience ko, hindi nga siya binagsak eh. 98, ay sorry, 89 ang score. Gusto 99. Where will I get that grade? Di ba? It is the educator's right. Di ba? Very ano eh. Very, ewan ko. Let me share I would not be naming the sharer yung course natin na to parang ano to eh. Parang radio program. You may want to share if you would like. Diba? And I would be reading it. So, coming from our message, sorry daw to disturb yung magpapaalam. Okay. No problem. Go ahead. Na nagpapaalam pala siya. Okay. I thought they were going to share something. Okay. No problem. We would we would just be providing itong ano na lang, itong recorded video for everybody's consumption. All right? So let me give you a case itself, an actual case decided by the Supreme Court, which has been the basis sa mga pangyayaring ganito. Okay, this is Camacho versus Coresis. Okay? A graduate school professor and the OIC of the Grad School of University of Southern Philippines was charged with graft. This is a public school, Southern University of Southern Philippines. That's why the case filed against him is graft and corruption. Okay, of graft cases brought by the complainants of ghost students in his Doctor of Education classes. In fact, ang nagreklamo sa kanya dito, mga co-faculty niya. Okay, perhaps siguro nainggit, ewan ko. Kung ano nangyari dyan. This is an old case already eh. So, a co-faculty complaint Mr. Camacho, complaint before the ombudsman that Mr. Camacho is committing graft and corruptions because he has ghost students. Kumaga, pinag-enroll na lang niya yung students, di na niya pinapapasok, di na siya nagtuturo. Basta mag-enroll kayo, okay na, pasado na kayo. So, ano nangyayari daw? Instead na mag-enroll yung mga students dun sa complaining complaining teacher o complaining professor because nang babagsak yun, yung mga students nag-enroll na lang dito kay Mr. Camacho. Okay? Kasi sure pass. Okay? Ganun ang naging nangyari dyan. Yan ang background sa kanya. So, kaya kinasuhan si Mr. Camacho of graft. Okay? Na nagkakaroon daw ng ghost students. So, hindi lang ghost employees ngayon ang uso, ghost students in his doctor of education classes. Okay? Fellow professors filed a complaint with the Board of Regent of USP. Later, however, sided with the administration of USP sided with the professor, with Camacho, and upheld that the grades given by the teacher to the students are good, are okay lang naman, are valid. So later on, aggrieved pa din, medyo inggit pa din, despite the fact na pinanigan na ng dean at the administration ng USP yung teacher, subject teacher dito or subject professor, they filed their complaint before the ombudsman. Grabe, no? So, what has been decided? What the issue first is whether or not there is indeed a commission of graft and corruption by allowing and passing students despite the fact of non-appearance in class. What did the Supreme Court decide? So, Supreme Court decided that there is no crime committed. In fact, mas pinagalitan ng Supreme Court yung mga nag-reklamo yung professors. Mr. Camacho was only exercising his freedom of education as an educator. The academic freedom of instructors, educators, or professors involves the means and method on how they would be teaching, on what they will teach, on how they will teach, and who will teach. Okay? The means and method is on the discretion of the instructor or the professor. What do you mean by this? Kung gusto ng professor na online, it is the professor's discretion. If the professor would not require a written requirement, it is the professor's discretion. If the professor would just require everybody just to be attending and listening to this discussion, it is his discretion. Then ipapasa ko. It is still his discretion. Ibabagsak ko, it is still his discretion. It is an exercise of academic freedom on the individuals enclosed to the educator. All right? Does the student also have academic freedom? So ito, we have discussed that there is academic freedom on the institution. Recently, we just discussed that there is academic freedom on the educator or the teacher. How about the student? Is there academic freedom on the part of the student? Well, to answer, yes, there is. It is not limited to the members of the faculty nor the administrative authorities of the education institution. It is also deemed granted in favor of the student body because all three, ano yung all three na yan? Three parties yan, as we have mentioned earlier. The administration, the faculty, and the student constitutes educational institution. There's no school if there's no admin. There's no school if there's no faculty. Especially, there's no school if there's no student. Because academic freedom is enshrined to the educational institution which is composed of these three parties. We could conclude that students also have and may exercise their academic freedom. It also operates in their own capacity. Okay? Again, the education institution is a three-way party. The administration, the faculty, and the students. Without one, it cannot stand on its own leg. Okay? Without one, it cannot stand on its own leg. And three of these parties exercises academic freedom. Okay? What are the two rights of the student? First is to choose the field of study. And second, the right to enroll until graduation if he was admitted. Again, I get I guess there's a student here. Oh, let me have this first question for our class. Is educators' academic freedom applicable to secondary education, Tony? Like you decide not to give the performance task and you give them all perfect scores. Well, again, academic freedom is mostly to answer this question. No? Academic freedom in education institution of higher education. Because since it is the Constitution provided that it is applicable to higher education, I would say that academic freedom in secondary education, which is yung high school, mga ganyan, is, kumbaga, not unlikely to be seen. Okay? For example, requirement na mag-decide the performance task, ganyan. Kasi itong mga performance tasks, this is are required by the curriculum provided by the DepEd. Again, later on, i-discuss natin to. So, secondary education, yung higher education natin na tinatawag yung tertiary o yung third level education. Because of the K to 12, sige, i-advance ko na yung discussion with regards to K to 12. Because of the K to 12, elementary, junior high school, and high school or senior high school, it's just one level. They are now called basic education. Since that is basic education, no? Since it is a considered now as a basic education, yung high school level natin, sa ano siya, medyo limited ang ating, hindi ko sabing medyo, limited ang academic freedom ng mga instructors dyan. If the institution provided na, ito dapat tatlo ang performance test natin as provided by the DepEd. Again, DepEd will provide yung curriculum na at least on a per semester, dalawang performance task kayo. That is the minimum. If you would like to have three, ay discretion mo na ngayon yun. That's the exercise of your academic freedom. But the mere guideline, you would have to follow it. Dalawa. E paano kung gusto ko wala? Ay, hindi pa pwede. Yun yung sagot doon. So again, there's also an opinion coming from our participants. No, it depends. Sa secondary students tend to abuse their freedom. Secondary students tend to, just her opinion, tend to abuse daw. Yeah, yeah, of course, every right is subject to ano eh. Hindi ko naman inaano na kapag may right ka, all encompassing, pwede mo nang gawin lahat eh. Right, remember, your right ends to the tip of the other person's nose, no? So yung rights natin, any right to education, right to religion, right to whatever, these are limited. Hindi natin pwede abuse. That's why yung state pa din has let's talk about academic freedom, no? They still have the supervisoral right, okay? The right of supervision, reasonable supervision. So attorney, depending on the governing body, right? Example, DepEd have their own RR. Yes. So ito, later on we would be discussing, no. Gusto ko sana ano siya, yung constitution muna tayo, then we'll later on move to K to 12 eh. Pero since there are questions already, ano, no. Ito kasi yung education natin, yung K to 12 natin is already considered as one level of basic education. Okay? So, yeah, DepEd na siya. So, there's our RRR, there are other circulars or implementing rules and regulation. When we say implementing rules and regulation kasi, there's a law provided there's a law that was issued by the Congress. Yung nitty-gritty on how to do it is being issued by the department or agency concerned through an IRR or implementing rules and regulation. So what if there is conflict between the IRR and the law? Well, the law will be upheld. Pero as to the matter of operations, the IRR shall be followed. Kasi yung law, mostly generic siya eh. Sorry, general siya eh. Pero yung IRR, very specific. Kailangan pumunta ka sa office na ganitong oras, ganyan. Yung how to do, on how to provide, sorry, how is being provided by the IRR. So, yan. Yung ano niya. So, mostly principles yung batas, then IIR provides the how. So yun, in basic education, DepEd. Sa higher education natin, yan, dyan na. Okay? So yan. So there's again, let me emphasize now. Students also has academic freedom, and that is their right to choose their course and the right to be enrolled until graduation. That is if they are being admitted and still subject to the rules and regulation of the institution they enrolled into. Uy, ano ba to? All right. Again, the right to enroll until graduation. Let us expound that, no? The right means the student has the right to complete the program until graduation, save only, ayan, so may limitation, save only for academic delinquency, kung bagsakin talaga and serious violation of school policy involves a violence. Remember Ateneo versus Kapulong. As long as the student passes the scholastic and academic requirements of the school and has not committed any serious violation of school policy, the student should not be deprived from enrolling in the subsequent academic years until his graduation. So not necessarily, for example, kumuha siya ng engineering, okay? Pwede mo sabihin ng estudyante na, oh, nakapasa na ako sa entrance exam, nakapag-enroll na ako ng first year. Unconstitutional yung three flunk rule nyo. Pag nakabagsak ako ng 3 subjects, debarred na ako. Is that unconstitutional? No. Because, again, the school or the institution has the discretion to provide rules and regulation on how they would be managing the means and method on the teaching side. Okay? Who to teach, what to teach, when to teach, and who will be taught. It is the institution's right of academic freedom. Okay? 4 yung factors ng institutional academic freedom eh. Who to teach, what to teach, when to teach, and who would be taught, yung admission. It is the institutional academic freedom. So yun, on that level, hindi siya unconstitutional because it is a rules that you had agreed upon. That upon enrolling in this school, if you failed 3 subjects, talagang tanggal ka. You should have read your handbook. Kaya very important sa sa first year or minsan bago pa mag first year, dinidiscuss isa-isa yung student handbook sa mga estudyante, sa mga freshmen. Kasi doon usually nagkakaroon ng problema. Hindi namin alam na ganyan. So, yun. Diba? Madalas pa require namin or we suggest to our clients that during the time of seminar, na-attend sila, required yun. Otherwise, hindi sila papapasukin or hindi sila ma-admit sa school. Napipirma yung parents along with the students so that everybody is well protected. So let us give an example of this one. No? Department of Education, Culture and Sports. Tingin ko alam niyo na to, very old case na to kasi Dex pa yung pangalan niya, no? Versus Santiago. Di pa siya DepEd, Dex pa ang pangalan nung ano natin, nung petitioner natin dito. What happened here, no? San Diego was a graduate of University of the East, UE, Bachelor of Science in Zoology. And he claims that he took the NMAT 3 times and flunked it many times. NMAT is a exam that students would have to take and pass before they would be able to take a course relating to medicine. So, ayun. Ang nangyari kay Mr. Santiago kasi, after graduating and taking the NMAT exam, he failed 3 times. Okay? There's a 3 flunk rule provided by DEX, now DepEd. Ay, sorry, now CHED. Na ang sabi niya is, pag bumagsak ka ng 3 times ng NMAT, you would be never become a doctor. Okay? You will never be able to take the exam again and be able to enroll in medicine, the College of Medicine, in any school. Okay? He was feeling aggrieved. Discriminatory naman yan. Di porket bumagsak ako ng 3 times, sa 4th time, babagsak ulit ako. In fact, kahit bumagsak ako ng 3 times, hindi ibig sabihin na bumagsak ako sa exam, sa NMAT, hindi ako magiging magaling na doktor. That was his contention. Okay? So he went to the Regional Trial Court of Valenzuela in Metro Manila to compel that he take again the admission exam and the fourth time, invoking that he has the constitutional right of academic freedom, of quality education. Okay? He has the academic freedom to choose his profession, sabi niya, highlighting the provision, constitutional provision that every student has the right to choose his profession. Ayun, nasabi niya. What did the Supreme Court decide? Well, the Supreme Court decided that the right to quality education is not absolute. It is a limited right. Every right is limited. All right? The Constitution provides that every citizen has the right to choose profession or course of study. Again, caveat, subject to fair, reasonable, and equitable admission and academic requirement. According to Mr. San Diego, yung requirement daw ng DEX of three-flunk rule of NMAT is discriminatory and unfair for him who would like to pursue a course or profession in medicine. Again, he highlighted not only because I failed 3 times that it is already decided that I would not become a good doctor, but it is already discriminatory on my end, sabi niya. What did the Supreme Court said? NMAT exam is a measure intended to limit the admission of medical schools to those who have initially proved their competency and prepared their medical education. In fact, nakakaya yung sinabi ng Supreme Court dito eh. Sabi niya, yung medicine daw is a matter of life and death. We would not like to have a doctor who is not competent as you have been shown, no? So according to Supreme Court, if you fail 3 times, you are not confident to become a doctor. Medyo masakit yung sinabi ng Supreme Court. Pero that's reality of life. Diba? Medyo mahirap nga naman yun. So again, to protect the best interest of the state and its citizens, the state provided these fair and reasonable grounds for admission. According to the Supreme Court, the three-franc rule is already a fair and reasonable. In fact, you have been given 3 times of a chance already to prove yourself to be competent and prepared for the medical education because this is not a matter of joke. This is a serious matter. Sabi ng Supreme Court. Failing 3 times is already a signal that you are not ready for this profession. Perhaps you may look into another profession. Perhaps you may become a good lawyer. Perhaps you may become a good dentist, maybe, but maybe not a doctor. No? In general practicing doctors natin. So that is a method. In fact, that is an exercise of police power of the state to protect the general welfare. Ikaw ba naman okay lang sa inyo in these participants, no? Na may mag-o-opera sa inyo na hindi naman sanay mag-opera. 'Di ba? That's a matter of common sense, sabi nung Supreme Court. Of course, we would like to give our lives kumbaga to a dependable doctors, hindi yung incompetent na masakit ang masakit man sabihin pero katotohanan. Principle of compulsoriness and education. Here's the K-12 issue eh. Hopefully everybody sa okay no. Anyways, medyo malapit na tayo sa end. So again, principle of compulsoriness and education. Compulsoriness and education means that all children of school age are required to enroll in elementary education as provided by Section 2, Paragraph 2 of Article 14 of the 1987 Constitution. This is, of course, without limiting the natural right of the parents to raise their children. When we say elementary education, no, this involves basic education. Bakit kasi elementary education ang nilagay sa Constitution? If you could remember, yung Elementary Education Act of 1953, lumang batas na siya eh, yung Education Act natin. Elementary Education Act, that was 1953. when the framers of the 1987 Constitution was thinking of how are we going to have the yung basic education compulsory. Kinapi lang nila verbatimly yung nandun sa Elementary Education Act of 1953. Kaya nailagay dun sa Constitution, elementary education. Later on, na-realize niya, uy, oh my gosh, mali yung nailagay namin. Dapat pala basic education. So nilagay na lang siya sa notes during discussion. No? Kasi during the time of this, may notes kasi yan, yung constitution na yan. So, elementary education is actually referring to basic education, including high school. Okay? So again, Elementary Education Act, ito yung sinabi niya, provides that it shall be compulsory for every parent or guardian or other persons having custody of any child to enroll such child in public school the next school year following the 7th birthday of such child, and such child shall remain in school until completion of elementary education. Okay? So it is, so dapat ano to, dapat very, dapat strict to eh. Okay? Kasi that is the, the state policy eh, that each student of school age should be going to school. Hindi dapat nasa kalye. And if you would look into the Elementary Education Act, to whom does the compulsoriness being directed? It is on the parents or guardian. So dapat ang may liability dito si parents or guardian. Eh bakit may mga batang kalye pa din? It's a matter of enforcement. And if you would refer also to the Constitution, dapat wala nang reason ng mga parents or guardian eh. Because the state shall provide free education naman. It should. It should, based on the Constitution. By theory, the state should provide free education, elementary and high school. Eh, of course, there's exemption. According to law, there's exemption. These are the only exemption according to law. Elementary Education Act. Number one, if the child is a transfers or enrolls to a private school, o hindi na siya dapat sa public school kasi mandatory dapat sa public school by minimum. Kung hindi kaya ng magulang sa private school, by minimum dapat ilagay sa public school. Exemption sa public school kung kaya mo ilagay sa private school. Okay, that's number one. Number two, the school to home of the child, the distance between the school and the home of the child exceeds 3 kilometers or is non-accessible to the student. Remember, this law is 1953. 3 kilometers, kayang-kaya na natin lakarin siguro yan. Kaya na ng tricycle natin. But I don't know, I haven't lived on 1953, but at that time siguro baka wala pa transportation na maayos. Kaya yung 3 kilometers, that is considered a far from home already, that would give an exemption to the student not to be enrolled in any public school once he had reached or she had reached 7th birthday. Third exemption, the child is mentally or physically defective. Ito mismo yung words ng batas ha. The child is mentally or physically defective. Medyo yung ganitong wordings ng batas hindi na tinatanggap sa language of the laws now eh. So mentally or physically challenged dapat yung bata. Pero in the old law, it provided defective. Anyways, I'm just sharing, no. Number 4, on account of indigency. Yan, sobrang mahirap. Okay, ayan, ito meron tayong sharer. No 1953 daw, hindi pa concrete kalimitan ang mga kalsada at walang regular means of transportation. Yan, thank you for sharing. Kung di nyo nalalaman, ano lang ako eh. Hindi, joke lang. So yun, so I think naman talaga. So 1953 there's no means of ano. In fact, if tingnan niyo yung language of law, 'di ba? Iba pa yung ano niya, how the law was created. No? Is mentally and physically defective. In today's language, hindi ganyan ang pagkakaano niyan. Number 4, reason to be exempted to this requirement of the law. Okay, if on account of indigency or kahirapan, hindi mo kayang dalhin yung sa school yung bata. Okay? So, kaya may mga ano, kaya may mga out of school youth talaga. And the fifth requirement, ito talaga medyo mapapapikit ka eh. This is to cover the, kumbaga, to cover the incompetencies of the government siguro, no? In because of excess enrollment. If there is excess enrollment in the public school, okay, hindi ka na ano, hindi ka na required na dalhin yung anak mo sa public school. All right? Now let's go to K to 12. Republic Act 10533, okay, or 1053 10533 or the K to 12 law. Okay, this sa trivia no, si Attorney Estrada, Joseph Estrada, ano yan, isa sa mga underwriters and isa sa mga nag-isip nitong batas na to, which has actually the objective of putting Philippines at par with other countries. Kasi in background dyan, when we having feasibility studies on that, no, there are only three countries in the world. Again, three countries in the world that does not have K to 12 system or program of basic education. And what are these three countries? Number one dyan is the Philippines, and the two other are African countries that does not even have water supplies. Okay, sa sobrang rare na 'yon, di ko na maalala yung ano. Ayun, Angola. So, in fact, one of their problems was water eh. Ba't pa nila iisipin yung education, di ba? So, ganong level tayo at that time, no? So, personally, despite the fact na kahit siguro hindi ako maging associate ni Attorney Estrada, no, I would even say that the objective of K-12 was good eh. The objective because this is the objective of K-12 was to put us at par with other countries. And again, by feasibility by study, there are only three countries na hindi pa nagki-K-12. Yan, one of them is Philippines and Angola. Yung isa, talagang African niya, di ko na maalala eh. So, yun. So, the passage of this law makes all levels of formal basic education compulsory. Kindergarten, elementary, and secondary education. Kaya nga dahil ano na siya eh. Kaya nga kung napapansin nyo kung to be technically correct and politically correct, ano ang tawag sa mga high school ngayon? Grade 7, grade 8, grade 9, grade 10, grade 11, grade 12. Why? Because they are considered basic compulsory education. Okay, basic education which are compulsory. Kasi sa constitution natin, ang nakalagay doon compulsory daw ang elementary. Pero ang intention talaga noon is yung basic education. And to have that aligned, tinawag na natin na lahat ng levels na ito as grade 1, grade 2, grade 3, grade 4 hanggang grade 12. To have it politically correct that these levels are all elementary. Okay, basic education as required. Okay? So hindi na pwede ngayon na sige hanggang matapos na yung anak ko ng grade 6 okay na. Tatanggalin ko na yung anak ko sa sa school. Hindi. Ha hanggang matapos siya ng K to 12 na ngayon. Yun. Djibouti. Djibouti. Ayan. This is just merely trivia. Ayan. Ayan. Thank you for sharing for the class, no. Nasa group chat natin yung yung the third country that still, so ngayon, dalawa na lang sila, Angola and yung country na Djibouti. Anyway, so ngayon, it is again compulsory that each student of a school age should be in school for kindergarten, elementary, until secondary education. So again, to be politically correct, we call it now kinder, grade 1, grade 2, hanggang grade 12. It is compulsory. Okay, it shall be compulsory to enroll the children in basic education. And we call it now, hindi na natin tinatawag as kindergarten, elementary, and secondary. We call it as basic education. Okay? Basic education ang tawag sa kanya to be politically correct. Pero of course, in layman, kung kausap natin mga kapwa parents, mga ganun, yung parang lang, layman lang, o tawagin na natin elementary, junior high school, senior high school. Okay, pero for us na when we're talking about of the law, when we speak of the law, these are all now called basic education levels. Irrespective of learning delivery modes and system until its completion. Tingnan nyo yan anticipating na si Atty. Estrada eh. Kasi sabi niya, wala pang pandemic nung ginawa to na 2013 pa lang to eh. Ang sinabi niya na doon sa ano niya, section 7 niya of the law, irrespective of the learning delivery modes and system. Siguro na-anticipate na ni Atty. Estrada na magkaka-zoom nun. Kaya sinabi na niya yan. Nilagay na niya yan doon sa batas, no? So, irrespective. So, it may be face-to-face, it may be via Zoom, it may be via Google Classroom, whatever modes. Alright? As long as it is in kindergarten, to grade 1 to grade 12, it is mandatory already. Okay? So there's a actual case regarding the constitutionality of the K to 12. There is this group of teachers, no, Council of Teachers and Staff of College and Universities of the Philippines. They contested the requirement of compulsoriness of K to 12. Okay? Sinabi nila unconstitutional daw yung K to 12, yung batas na ito. On the basis that the Constitution or the 1987 Constitution provided that the compulsoriness of education is limited only to elementary. Kasi yung K to 12, ginawa niya lahat ng levels from kinder to grade 12, ginawa niyang basic education which is compulsory. Eh yung batas natin, yung constitution natin, ang sabi lang elementary. So bakit mo dadamihan yung compulsoriness? Kung ayaw ng magulang pag high schoolin yan, hayaan nyo sila. In fact, ang isang contention dito, one ground of their contention is that kung ayaw nila mag-grade 12 at gusto nilang mag-college agad, mag-college na. Diba? Kasi at that time, mawawalan kasi ng first year and second year, mawawalan ng enrollee sa mga college. Kaya kino-contest nila yan. Okay? Ano lang yun, a little bit of trivia, no? So yung kino-contest nila yung compulsoriness of K to 12. Hindi na daw tapat yan. Tsaka dadami pa yung tuition na babayaran ng magulang. So, in fact, the compulsoriness is only for elementary. Hindi daw ba unconstitutional yun, sabi ng mga nagko-contest na groups na ito. The Supreme Court decided that it is not unconstitutional. There is no conflict between the K to 12 law and the Constitution. Because as we have provided and we have mentioned before, the Constitution provides the minimum standards. Okay? Again, the Constitution provides the minimum standards, policies, guidelines. If there is a conflict between the Constitution and the law, the Constitution shall be upheld. However, there's no conflict. In fact, the K to 12 law enriches the requirement of the Constitution. Pinagbuti pa niya, pinaganda pa niya. And in fact, when the Supreme Court went through itong records of the constitutional frameworks at in-invite pa nila yung mga constitutional frameworks diyan. Isa sa mga constitutional frameworks natin diyan is a member of the Supreme Court himself, Mr. Supreme Court Justice Dabide. Siya mismo nagsabi na ginaya lang kasi namin nung 1987 at nung 1986 para sa 1987 Constitution, ginaya lang namin yung Elementary Education Act of 1953. Kinampi-paste lang. Pero ang intention lang talaga namin dyan sa constitutional frameworks is the basic education. When we say basic, it is now on the discretion of the state. What is basic? Okay? Kailangan ba yung college is basic? It depends ngayon sa state. Diba? Which is going to be provided under the law, which is the K to 12 provided what is basic education. And the law provided that basic education is kindergarten until you reach grade 12. Kaya, gandun. Alright? So, it is not unconstitutional. So, it actually, ito taxes na to eh. It actually enriches what the standard of the Constitution provide. Let me give you another before we end the session for today, because next session, next slide natin is taxation which is also Constitution, pero for next week's discussion na lamang po. Let me give you another no. Recently there was an issue once in a public forum made by the Department of Education with regards to the curriculum of K to 10. Marami ang online keyboard warriors natin nagsabi, pinalik sa grade K to 12. Ay, ba't pinalik sa grade 10 lang? Nawala na yung 11 tsaka 12. That is not the intention of the Department of Education, ha? Starting starting the school year of 2024, what has been changed or amended is the curriculum, the matatag curriculum. And I don't know if everybody's familiar with that already, no? The matatag curriculum, which stands for make make the curriculum relevant to produce competent and job-ready, active and responsible citizen. Take steps to accelerate delivery of basic education, facilities, and services. Take good care of learners by promoting learner well-being, inclusive education, and positive learning environment. And G, matatag, give support to teachers and teach better. In fact, yung sinabi nitong nung ating matatag curriculum is revising only the curriculum of kindergarten to grade 10. Yung changes lang sa delivery, modes of delivery and the contents of science, math, physical education of of kindergarten to grade 10. The contents lang, hindi binabalik sa grade 10. Because sabi nila, yung grades 11 and 12, it would be for further, yung curriculum nun is for further studies. But for for kindergarten to grade 10, ito na yung in-issue nila, which is readily available doon sa ating sa ating sa ating DepEd website. Kasi there are some clients that been asking if wala na bang 11 to 12, di na ba nila i-offer yun, gano'n, because of the matatag. No, that's not the intention, but just to change the contents of the curriculum. So let us end here. Hopefully everybody was able to learn something or to refresh something, no, coming from, no. And it's been an honor for me to be part of this course for this graduate school of St. Paul University, Manila. Thank you for having me. And we'll see again by next week, same time, 1 o'clock. And hopefully we will be able to end then. Siguro mga 2 hours. We spent 2 hours almost. No. For our attendance, yan na lang. Dito sa chat natin, it will be recorded. Just type present. Okay. Just type present or thank you, and everybody would be dyan. Doon sa everyone natin i-chat, wag direct message. So yeah, kasi if you're not aware, Zoom provides itong mga group chats natin. Recorded din pati yung group chat natin. So just type present and it would be recorded as your attendance. Thank you very much for having me. Please, before you leave this class, kindly type present in this everybody group chat. And kindly wait for the email for the for the recorded session if you would like to replay it. Yan. Yan.
Thank
All
you
right,
po,
all right.
attorney.
Thank you very much.
Thank you.
If there's no any other questions,
Thank you po.
thank you.
Thank
Thank
you
you.
po, attorney.
I'll be
Opo.
stopping the share, and also I'll be stopping the recording. Sarano. If there's any question, thank you very much and have a great day. All right.
Thank you.
Thank you.